I'm Sandy Gifford, and I direct the Latrobe Refugee Research Center here. And I'd like to cut to the chase and do the introductions, and to introduce our three speakers, our three Daves. Now, I want to start with David Mann, who, in the middle, who is the director of the Refugee and Immigration Legal Center and has been the leader of the recent successful High Court action. And I have to say, I've known Dave for many years, and he's also been highly successful as a behind-the-scenes advocate in this whole area of law. Many successes, and sadly, some that weren't successful, and I think it's really important to acknowledge so much of the work that actually happens not in the public eye. Our second Dave, David Marr, is a senior journalist with the Sydney Morning Herald. Many of you will know him in terms of his public commentary and political commentary. He's also the co-author of Dark Victory, which is a tragic and riveting read about the politics, the Howard election in the Tampa. And if you've not read it, it has not passed its use-by date. And our third Dave is Dave Collette, which is our recent movie star on Sending Them Back, the SBS series, which is actually still online, I believe, if you haven't seen it. Go back to where you came from. Dave is also a former Latrobe student, did his PhD here, and also is an author of Following Them Home, which was really following some of the failed asylum seekers who had been sent back, and also a more recent book called Stormy Weather, looking at the issues of climate change and forced migration. So with that, I would like to welcome all three of our panelists. What we'll do is we'll kick off with each of them talking for about 15 minutes. And then we will go into about a 20-minute more debate panel discussion, and we'll reserve 15 to 20 minutes at the end for questions. So we actually had the order, Dave Collette, to start off with you. Are you still happy to do that? So welcome.
Thanks, Sandy, and I'm sorry that I'm late. Nearly 2 decades ago, not long after mandatory, non-reviewable and indefinite detention of non-citizens who arrived in Australia without prior approval was made law, the then chairman of the Joint Standing Committee on Migration wrote a chapter in a book called Protection or Punishment. Jim McKernan's chapter was called The Political Imperative: Defend, Deter, Detain. The title clearly suggests that there was no other political choice than to defend Australia's borders against the threat of asylum seekers and refugees arriving by boat, a threat, by detaining and thereby deterring them. The underlying reason for this political imperative was, it would seem, because the Australian public demanded such a response from its political leaders. The discomfort of many Australians with the boat arrival of asylum seekers is long-standing. Conservative sociologist Catherine Betts, who in 2001 analysed 25 years of opinion polls, found that Australians' antipathy towards asylum seekers arriving by boat was, quote, a slow and growing trend over the last quarter of a century. More recently, the Scanlon Foundation found Australians' negativity towards asylum seekers arriving by boat continued. So what underpins our attitudes towards asylum seekers arriving here by boat? How are they shaped, and how might they be shifted? And does the SBS series Go Back to Where You Came From reveal anything about these questions of attitude? It's a truism of the left, I think, that hostile attitudes towards refugees and asylum seekers are the result of ignorance and fear. Ignorance about who they are and the nature of their plight, and fear that somehow they're threatening, that the perceived difference of asylum seekers and refugees represents a fear to our lives and our well-being. In a sense, Go Back tested this hypothesis. How would people's attitudes be affected if they spent time walking in the shoes of those about whom they were ignorant and feared? According to Inga Clendenin, humans have a unique talent for stories, for telling them and learning from them. They are our most economical technique for expanding experience. Hearing them, we have a sense that we can stand, that we are indeed standing in another person's shoes. When the stories are true, that experience is a powerful incitement to action. So Go Back sought to stand people in the shoes of others in an experiential sense, and to capture that experience on camera for an audience to see. As far as the experiment went, I think it tells us a variety of things. Certainly some of the participants had their attitudes and opinions challenged. Adam, for example, thought that asylum seekers were taking our jobs. During Go Back, he accompanied Thar, one of the Iraqi men he lived with. He accompanied Thar to work. Thar's employer said that he struggled to get workers to do the job that Thar was doing. So Adam began to question what he had assumed was self-evident. Similarly, he and Darren and Glennie were deeply affected by meeting with asylum seekers at the Villawood Detention Centre. They became more informed, but it was not just information, it was personal experience. For Adam, the experience was profound. Similarly, Raquel, a self-confessed racist, for her, the experience of meeting people and being with people who she had viewed as somehow lesser than herself had led to a dramatic shift in her attitude. By knowing someone, by crossing the threshold between self and other, between us and them, some of the participants began to change their attitudes. If ignorance and fear, or their opposites, shape our attitudes towards refugees and asylum seekers, so I think does a sense of entitlement. When we speak about good refugees and bad refugees, a dichotomy that's central to Australian political discourse, then we are implying our sense of entitlement. When we speak about the need for refugees to be grateful, or about proper channels through which asylum seekers and refugees ought to seek protection, sentiments that most of the participants on Go Back expressed, then we are also implying our sense of entitlement. We imply that we're entitled to make these judgments. In terms of Australia's response to refugees and asylum seekers, we assume a position in relation to the nation. We occupy a privileged place within the nation. Now, there is something to this position and to its general appeal. Nations play an important part in the lives of many people, including as a sort of meaning-giving thing. So a sense of ownership with regard to the nation is not without foundation. Further, an important function of the state is to manage its territorial borders in the national interests. But states do not have unfettered rights in this regard. Our entitlement to decide who comes and the circumstances in which they come is not absolute. The sense of entitlement that people like the Go Back participants felt with regard to the state and asylum seekers arriving by boat may also be limited by something else, a greater sense of justice. If refugees by definition have had their fundamental human rights violated, then it makes sense that their rights be reinstated. If this is so, then where do the rights claims of the likes of Ray, Adam, Darren, Raquel and Roderick to a place within the nation fit in relation to the more fundamental rights of refugees, whose most basic rights to physical integrity, to safety and security have been violated? There is also something bigger than the sense of national entitlement that shapes our attitudes towards asylum seekers and refugees. The Go Back participants reflected a sense that somehow we ought to determine the rules by which refugees should play. Partly this is ignorance, and by this I mean a lack of understanding that life is not always as ordered in other parts of the world as it is in Australia. The participants on Go Back got a sense that the international refugee protection system is bigger, more clumsy, more under-resourced, and in places more corrupt than they had imagined. Maybe this deeper understanding had a part in the attitudinal shift that some experienced. If ignorance is part of what leads us to claim forthrightly that there is a right and a wrong way to go about seeking international protection, then a lack of moral imagination and a sense of arrogance are other ingredients. By a lack of moral imagination, I mean that we repeatedly fail even to try to comprehend what it might be like to be dislocated, to be victims of war, survivors of torture and other serious human rights violations, to be forced to flee family, friends, community, place. And then it is arrogance on our part, having failed to try to comprehend what it might be like to be a refugee, to suggest that there is a proper way in which to find protection and to cast judgment on those who do not follow this route. The sense of entitlement based on our place within the nation and the world means that we are the arbiters of what is fair. And fairness is at the basis of a central claim in Australian political discourse about asylum seekers, namely that asylum seekers and refugees who get on boats take the places of other refugees who are unable to afford the services of people smugglers. Now, this argument has strong resonance, of course, in the Australian community. The notion of a fair go, albeit limited to those deemed part of the in-group, is embedded in the national psyche. In its more populist manifestation, the claim to fairness is articulated as guarding against queue jumpers who steal the places of the more vulnerable. Now, there is good reason to be critical of these sorts of metaphors, not least because the notion of an orderly queue is a misnomer and the criminalising language is nonsense. Rather than having sinister intentions, asylum seekers coming to Australia set out in search of protection, and maybe meeting refugees who had arrived by boat or who had attempted to or hoped to come to Australia by boat helped some of the participants on Go Back to understand that asylum seekers do not intend to rip off the system. Rather, they're seeking something entirely reasonable for themselves and their families, a life free from the fear of grave human rights violations. Again, a challenge to ignorance and fear. There is further reason to be sceptical about fairness claims in these matters. Claims to fairness pretend to be set against a neutral backdrop. They're claims that, while deeply politicised, are presented as being removed from politics and power. So, for example, a number of the participants on Go Back suggested that it was unfair that millions of dollars was being spent on asylum seekers when other Australians are in need. In a similar vein, Darren was recently on a current affairs program as part of a story about unaccompanied minors being taken from detention and accommodated in community-based housing. He complained that it was an issue of fairness, especially since Indigenous Australians and our homeless are not gaining access to those same resources. But there are things that are implicit in this argument that need to be made explicit. What remains hidden in many fairness claims is the relative power and privilege of those making the claims. So, for example, Darren's own position in the fairness equation goes unquestioned. Instead, the equation remains between, on the one hand, asylum seekers and on the other, vulnerable Australians. The vulnerable are pitted against the more vulnerable, while our own privileged place exists unquestioned in the background. Of course, this suits those of us who retain positions of privilege. In fact, rather than being somehow neutral in the competition between the vulnerable, the Australian government, in our national interest, decides how resources are spread between those less vulnerable. Asylum seekers do not wish to be detained at the expense of needy Australians. That is a decision of the Australian government based on the political imperative that Jim McKernan identified. Of course, there are equity questions in all of this because there is never enough protection to meet the needs of all who require it. How ought we to respond to greater or lesser needs? Even if we accept that they all have a right to international protection, how should we balance the needs of refugees in desperate circumstances in camps and urban slums around the world against those who are able to come to Australia by boat? Now, I don't know the answer to the questions, but we would be better placed to work them out if we didn't attempt to demonise and play vulnerable people off against each other. We might also be able to have the discussion more ethically if we were able to recognise our own privilege as a central part of the equation. I want to conclude by returning to Inga Clendenin. I think that she's onto something when she argues that stories are our most economic way of expanding experience. But stories are not enough. Indeed, for some, even more literally, walking in the shoes is insufficient. Beyond stories, something more is needed. It's the capacity to let the imagination go to certain places. Some, it seems, can read a narrative and let their imaginations take them into the lives of others. Other people, such as Ray, in the case of refugees, needed more literally to feel what it might be like to live like the other. She needed to meet them, to sit with them, share their food, to laugh and to cry with them. But we cannot all do this all the time. We need a moral imagination, a sort of openness of the heart, a preparedness to be moved. One of the things that I think that can get in the way of this is a sense of ideological certainty. Part of what I learned from the Go Back experience is that for those whose political views are somehow tied to their sense of self, it's difficult really to walk in another's shoes, to imagine their circumstances, including truly to contemplate their dilemmas. There is too much invested in the existing worldview to do such a thing, too much to lose, including a sense of certainty and stability. In such cases, stories and even personal relationships are not enough to do the work. Indeed, stories and the imaginative capacity to allow them to impact on us are not enough, not even for people like Ray and Adam. As well as a moral imagination, we need to be able to do the critical thinking, to think structurally, to think about power, including our own power, and to be able to extrapolate on particular stories into the more general. There is a role for leadership, including political leadership, in assisting Australians to undertake both these tasks, to assist in the storytelling and in helping to understand the stories, both from an emotional perspective and by placing them in a political and policy context. In the absence of good political leadership, Go Back, which took the refugee issue beyond the daily political point scoring and put it into the hands of real people, gave us an insight into ourselves and into the experiences of refugees. It expanded not just the participants' experiences of the world, but those of many of the show's viewers too.
A bit of history. The dismantling of the White Australia policy was one of the great achievements of Australia since Federation. It called on enormous political skill. It required Australia to rethink its sense of its own self, and it was fraught with great political peril. But both sides of politics knew that it had to be done, otherwise Australia would become a pariah state in the world. We had no choice but to face the challenge of taking apart a system which did not allow coloured immigration to this country. And the decision was taken in the late 1960s into the middle of the 1970s that neither side of politics would take domestic political advantage of the remaining large number of Australians who were profoundly opposed to this change. Until a few weeks ago, I used to lament that the last time a poll was taken of people bluntly asking them what they thought of coloured immigration to this country was 1984. And at that time, 27% of Australians disapproved of anyone other than whites being allowed to come and live in this country. But the splendid Scanlon Foundation survey of a few weeks ago reproduced almost that same figure in the objections of Australians to immigration from what was loosely called the Middle East, which included both Lebanon and Iraq. So there remained in Australia, and remains in Australia, a large rump vote that could be taken advantage of if a party wished to take advantage of it to cause domestic political havoc for the dismantling of the White Australia policy. But a truce was called between the parties in order that essential work be done. But within almost months of the last of the official structures of White Australia being demolished, a boat turned up in Darwin Harbour with 5 Vietnamese on board. They had sailed down from Saigon using a few pages of a school atlas and a compass, and they reached Darwin Harbour in early 1976. A narrative could have begun at that point of greeting them as heroes. They were, after all, fleeing communism. And Australia's idea of refugees had always been that they were fugitives from communism. We signed up to the Geneva Convention after the war, partly as part of the world's apology to Jews for what was allowed to happen to them before the war, but partly also to clear Europe of people fleeing communism. And the Vietnamese in the late 1970s coming to Australia were fleeing communism. They were part of that same narrative. They might have been greeted as heroes, but they were not. It was decided at that point by both political parties that the fears of Australians, that the appearance of these unwanted, unsorted, unselected arrivals caused, that the fears would be appeased. And when we asked the question, at what point did Australia get onto the wrong track with asylum seekers who arrived by boat, who I will henceforth refer to, without any disrespect whatever, as boat people, it was right at the start. Because right at the start, the fears of Australians were appeased, and right at the start, both sides of politics pledged to stop the boats. Now, this is, in world terms, an extraordinary pledge, then and now, to stop the boats. It is not a pledge made by Greece, where hundreds of boats, perhaps even thousands of boats, arrive every year. It is not a pledge made by Italy. It is not a pledge made by Spain. It is a pledge made by Australia, and it was made 35 years ago, and it was made by both sides of politics, and it remains the fundamental pledge of both sides of politics. We will stop the boats. We won't police the system. We won't limit the system. Competence as a government will be defined by stopping the boats. Now, this is an extraordinary pledge to the Australian people. You'll stop them. Now, there is a lot of sentimentality these days about what Malcolm Fraser achieved in the late 1970s and early 1980s when the Vietnamese were pouring out of Vietnam. And it is undeniably true that he managed an almost revolutionary absorption into Australia of tens of thousands of Vietnamese. But he did everything he could to stop the boats. He didn't want them coming by boat. He understood, as both sides of politics understood, the deeply fearful response of the Australian people to the boats. So, for instance, in the Fraser years, teams from the Immigration Department went to the holding camps along the coast of Malaysia and chopped out the hulls of boats in order to prevent them sailing. They broke their engines in order to prevent them sailing. And in the end, only a couple of thousand Vietnamese in that first wave of boats actually reached Australia. We took in about 100,000 Vietnamese, and less than 5,000 of those actually arrived by boat. Then the boats completely disappeared. They just absolutely disappeared for all of the 1980s until some Cambodians started to arrive by boat in the late 1980s. There is a splendid political symmetry to this story. There have been 4 waves of boats, 2 while the coalition was in office and 2 while Labor was in office. So by the time the boats returned, the Hawke-Keating government was in office. It had always been the wish of the Immigration Department to formalise what had been at times an informal arrangement to place in detention anybody who arrives here without a visa. We are a visa-crazy country. It's one of the international aspects of Australia. We're a visa-crazy country. We're an island state. Island states always have an exaggerated sense of their capacity to control entry into their country. We are an island state, one of the few island states in the world, and of course we're the cultural inheritors of that other great island state, the United Kingdom. And we bring to this country many of the same instincts of ambitions, at least, of absolute control of who comes into the country. Poland can't do that because you just wander across the border. But somewhere like the United Kingdom can, somewhere like Australia wants to be able to do it. We are a visa-crazy country. And the Immigration Department had always wanted to be able to put into the clink people who arrived here without visas, and they pushed the Hawke government to do this. They pushed the Hawke government to do this. And finally, after a devastating year in which 216 people had arrived by boat, mandatory detention was introduced to Australia. And it was introduced with the enthusiastic backing of left-wing unions. Left-wing unions were historically extremely hostile to the arrival of coloured people in an unregulated fashion, and it was put in place. This was a second terrible step that Australia took, an absolutely terrible step, mandatory detention. And the next terrible step is that the High Court ticked off on it. Here was a parallel system that was clearly punitive, intended to be punitive. The political discourse was all about the deterrent effect of placing people in detention, and yet the High Court was persuaded that this was merely administrative arrangement, that detention would be brief and that all would be civilised, and it was really no more nor less than detaining people with yellow fever or some disease. This was a tremendously unfortunate step in Australia. If the High Court at that point had said, we are not going to set up a parallel punishment system in this country for people who arrive lawfully at our borders requesting refugee protection, we would not be in the mess we are today. The mess we are in today is very largely because of mandatory detention. Time's rolled on, and the clock is rolling on. I want to make just a couple of more points about the basic politics of the boats, which I think we overlook. Both sides of politics were in lockstep on the boats until the rise of the One Nation Party in the late 1990s. The boats had returned again. The third wave of boats, largely made up of Iraqis and of Afghans, appeared on the horizon when Howard was in office and when One Nation was nipping at his heels. And it was One Nation that suggested the ultimately uncivilised act of pushing these boats back out to sea. A notion that Howard himself resisted and was still resisting into the middle of 2001. There's a famous radio interview he did down here in Melbourne where he said, we're a civilised country, we don't do that kind of thing. And a few weeks later, he did it with the Tampa. And that was the politics. And at this point, the lockstep meant that Labor was in no position to set up any kind of contrary policy, any kind of alternative and more civilised policy and calmer policy to deal with the arrival of this wave of boats. Labor was trapped. It was trapped because many people inside Labor absolutely supported everything that Howard was doing. It was trapped by its own record on the boats, and it was trapped because there was an election coming within months. But this was the point at which the coalition saw the possibility of using the residual fear of the boats in the Australian community to damage the Labor Party. This was the point at which the politics of the boats entirely changed. And what we're seeing today is another round of that changed politics in which the coalition extremely aggressively is beating up on the government because of the boats. And Labor is trapped. trapped by its own wishes, trapped by its own past, trapped by its record of going along for so long with the fundamental notion that this country is about stopping the boats. So Labor is trapped. Labor is also extraordinarily foolishly trapped because it has allowed Tony Abbott to set as a criterion of effective government stopping every last boat. So each boat that appears, and always a marvellous photo opportunity for the press, and at least these days we can photograph them, we couldn't under Howard, each boat that appears is projected by the opposition as a failure of government, not as the arrival of people in need of protection, but as a failure of Labor, a failure of government. And Labor has allowed itself to become trapped right inside there. And yet, from the very start, there has always been a strong constituency in this country for dealing decently and calmly with people who arrive here by boat. Catherine Bett's name was mentioned earlier. She wrote, I don't agree with some of the political conclusions that she reached, but she wrote this marvellous paper, which is available on the internet, looking at the polling of public opinion up to 2001. And you can see there, even though there is an alarming third of this nation that does not ever want anybody who arrives here by boat, unsorted and unwanted, ever to be allowed to live in this country, there is nevertheless a majority, nearly all the time a majority, for dealing decently with boat people and calmly with boat people, accepting our responsibilities under the Geneva Convention and letting them live here if they turn out to be refugees. But the politics of this country for nearly 35 years has played to the hostile minority rather than play to the calmer and more civilised majority in this country. And we are trapped where we are now, not so much because of the fears of this country, but of appalling leadership that has allowed those fears to dictate how this government behaves, how this country behaves. More of that later.
I'd like to invite David Mann and to be our third speaker, and I'm giving you your 15 minutes. I think we really do want to take that and hear what you have to say.
Absolutely. Well, thank you. And look, it was just over 2 months ago, amidst the contemporary politics that David just described, that I was cooking for the kids on an early Saturday evening at my home in inner city Melbourne, and I received a call for help. It was a distress call relayed through a young Canberra-based legal aid duty lawyer. He was probably awaiting his first call to advise someone that they'd been arrested for being drunk and disorderly. Instead, he told me that he just received a call out of the blue from a group of men incarcerated on Christmas Island wanting advice. These men, some of them from Afghanistan, feared being expelled to Malaysia. The matter was urgent. How urgent was unclear, but there was a sense that expulsions could happen as early as Monday. The lawyer had no experience in refugee law, but had the presence of mind to send a message out to legal networks throughout Australia to find out someone who may in fact know something about refugee law. And that's how the call for help hit my kitchen bench. It was not a conspiracy to get the law in to rule on the policy. It literally happened like that. Later that evening, I spoke by phone with some of the Afghan men seeking this help. They were petrified. They explained through the aid of an interpreter that they had recently arrived by boat in Australia seeking protection from brutality in their homelands, only to be told by Australian officials that they would not be allowed to seek protection as refugees in Australia. Instead, they were to be sent to Malaysia. They told me they feared being severely harmed in Malaysia and that they faced deportation from there to life-threatening harm in their homelands. The group of 36 men sought two things. First, that they not be expelled to Malaysia, and secondly, that they be allowed to stay in Australia and seek refugee status here. That was the brief from start to finish. As lawyers, we were asked to provide legal assistance to challenge the lawfulness of their expulsions, and secondly, to secure assessment of refugee status for them in Australia. And that is what we did. The brief was not to challenge the policy of the Malaysian Solution. That was not the brief, and that was not the task. Despite the sound and the fury that David has just very neatly described, at no point did the legal team act on anything other than a request for legal assistance, and we as lawyers responded to that request. So that evening and the following morning, a legal team was assembled comprising some of the finest in this field in Australia, such as Debbie Mortimer SC, Richard Nile SC, and leading law firm Ellens Arthur Robinson, all acting pro bono, that is, all acting for free. And I think it's a fine thing in this country that people as vulnerable as this can access such assistance. Within 24 hours on Sunday evening, we were before the High Court of Australia in Melbourne seeking an urgent injunction to stop the government from expelling any of our clients to Malaysia. It is here that we learnt how urgent the matter was, and that is that 16 of the men were to be put on a plane at 11:30 a.m. on Monday morning, on a plane to Malaysia, to be sent to a place with a long-standing history of serious and systematic mistreatment of refugees and a clear absence of any legal protections to ensure that they would be free from abuses that so many others have and continue to suffer in Malaysia. They were the stakes. His Honour Justice Hayne granted an injunction that evening, effectively preventing the planned expulsions on Monday morning. And on Monday afternoon, that is the following day, he extended the injunction pending the determination of the matter. About 4 weeks later, the High Court emphatically ruled, 6-1, that the government's proposed expulsion of these people and others to Malaysia was unlawful. Almost 10 years to a T after the Tampa incident, how had it come to this? To understand the context of the recent High Court challenge, we need to rewind a decade to the time of the Tampa. The facts are notorious enough for me not to recount them in any detail. Suffice to say that, contrary to past practice, 433 asylum seekers en route to Australia were refused entry and instead expelled to Nauru for processing of claims and warehousing. The so-called Pacific Solution policy spawned the prototype, that is, the model of offshore processing. In action, it involved two essential parts. Firstly, exclusion. Exclusion from seeking refugee protection under Australian law. And secondly, exile. That is, exile to another country in the region, Nauru or Papua New Guinea, for assessment of refugee status and warehousing. In policy terms, the rationale was driven by an imperative of essentially deterrence of people coming by boat. As David put it neatly, stopping the boats. Stopping people who were seen to have arrived by way of what was called secondary movement, that is otherwise referred to, less fortunately, in some circles and in fact in our public discourse, as queue jumping. That is, it was seen that these people coming from Afghanistan and Iraq primarily were seen to have forsaken protection elsewhere on the way to Australia. They'd somehow jumped a queue. The fact is, and I must again return to this much repeated fact, and that is that there are no real queues and no real protections accessible in the region en route to Australia, but that didn't seem to get in the way of a foundation of policy during this era. Crucially, the policy was avowedly to be fully consistent and compliant with Australia's obligations under the Refugees Convention. Expulsion of asylum seekers must not and does not breach our treaty obligations, we heard very often from our political leaders. It is in this context that Section 198A of the Migration Act was enacted by Parliament. This is the provision, still on our statute books, I think, which empowers the Minister of the day to declare a country to be suitable to transfer asylum seekers to instead of letting them stay in Australia for processing. It is this provision that was used to declare Nauru and Papua New Guinea to be suitably safe. And it is the same provision which was used by Minister Chris Bowen on 25 July of this year to declare Malaysia to be suitably safe for expulsions. It is this provision which became the focal point of the High Court challenge. This law requires that a declared country provide three key things. Firstly, access to effective procedures for assessment of protection need. Secondly, protection. And thirdly, relevant human rights standards in relation to that protection. Now, this policy of Pacific expulsion that I've referred to constituted a key foundation of the architecture of one of the toughest and most comprehensive anti-asylum seeker systems in the Western world. And from a human rights perspective, I think it's fair to say was a strong contender for Western world's worst practice. Key features included mandatory indefinite detention, temporary protection visas, the Pacific Solution, naval repulsion of asylum seekers arriving by boat, and excision of Australian territory to preclude people from seeking asylum in Australia at all. And what it did was, I think, also graphically illustrated one of the fault lines that we continue to witness in refugee policy in this country, and that is essentially a radical deviation from mainstream standards in our legal system that otherwise apply fairly universally. And they include access to the rule of law. They include habeas corpus. They include anti-discrimination or indeed equality principles. And they include access to legal advice. They include access to the courts. In many ways, this policy represented a graphic illustration of this systematic deviation from the golden threads of our legal system, which I think we need to return to. Another thing which I think is important to refer to here is the fact that the policy of Pacific expulsion also caused mass and severe and lasting harm to people who were ensnared in it. Recently, we've heard from our political leaders that somehow Nauru is humane. And I quote, humane. Not only is that wrong, it's grotesquely wrong. All the evidence is that that policy of expelling people to languish in limbo, whether in Nauru, in PNG, or possibly elsewhere, is likely to cause people the same devastating harm that it did in the past. Now to the decision briefly. The decision recently in the High Court in what's been known as M70. The decision itself was a classic decision about the rule of law in this country. It was not a decision about policy, it was not a decision about politics, despite all the sound and fury, the white noise about that. In fact, what it was a decision in relation to the Minister's declaration under Section 198A, that provision being the provision that was introduced during the time of the Tampa. And essentially, what the court found was that the expulsion of our clients, the proposed expulsion of our clients to Malaysia under that declaration would be unlawful. And here's why. The declaration, to remind you, is a declaration made under a statute, the Migration Act. Parliament, about a decade ago, decided to enact a provision which required that if there was to be a transfer of anyone from Australia for processing elsewhere, that it be done under certain conditions. Those conditions are not policy, they're law. And that law is contained in Section 198A itself. The court found that in essence, that section requires something more than for the minister making that declaration that someone can go to another country. It requires more than that the minister thinks or believes that it's acceptable to do so. But instead, for example, that the access to procedures for determination of refugee status and the protections must be provided as a matter of legal obligation, domestic or international. Not just whether the minister thinks or believes that it's acceptable to expel the person, but that as a matter of legal obligation, that there are in fact effective procedures and there are in fact adequate protections in place. The relevant obligations that the court looked at and said were required is that the country must provide, and in this case Malaysia was the country in question, must provide people who have refugee status with rights, for example, which are enshrined under the Refugees Convention, which include education, religion, employment, housing and access to the courts. The court went on to say that a country provides access to effective procedures for assessing protection if its domestic law provides for such procedures, or it is bound by international obligation to allow the UNHCR to undertake procedures, or is bound by international obligation to do so itself. In none of those situations is Malaysia so bound. It went on to say that there must be, I beg your pardon, it went on to say that in relation to Malaysia, that Malaysia failed the test under law in this country because, firstly, it does not recognise the status of refugees in its domestic law and does not undertake any activities such as registration, documentation or refugee assessment. Secondly, Malaysia is not a party to the Refugee Convention. And thirdly, the arrangement with Australia to provide rights is not binding. It's a statement of political intention. That is ultimately the essence of the ruling, and that is that if a minister of the day is to declare under this provision that someone can go to another country, that that country is suitably safe, if you like, that there have to be certain objective facts in place. It's not just a matter of the minister thinking or believing that it's safe enough to do so. And in a sense, the court was really talking about ensuring that anyone that is expelled to another country, that country has reflex rights. That is, that it ensures by a matter of legal obligation that there are reflex rights in that country under the Refugees Convention. I want to briefly now turn to a couple of other matters. And firstly, as has been asserted, did the court change the law? The court did nothing of that sort. The court did something very normal and common in this country, and in fact it discharged its function in that way, and that is certain people, that is 42 asylum seekers, asked the court something very normal and reasonable in this country, and that is, does the government have the power under law to do that which it is proposing to do, in this case expel them to Malaysia? And the court looked at the law, looked at the facts, applied the law to the facts and found that it was in fact unlawful. It was in many respects that simple. The second point, did the court, as has been alleged by certain political leaders, miss an opportunity, and I paraphrase, to break the people smugglers' business model? Well, in fact, the court didn't miss an opportunity to do so, because that was not in fact the function of the court. The court doesn't seize upon, and is not called to seize upon under the separation of powers, to pursue policy objectives of a government. The court is, of course, its key function is to apply the law to the facts properly, and to interpret the law in light of those facts, and that's in fact what it did. I want to very briefly, in closing, conscious of the time, just put out something by way of, I guess, a proposal about, or a discussion that might prompt some questions, and that is, where do we head to from here in terms of the sort of situation that we're mired in? There are a couple of false debates, I think. One is, and we need to move beyond these debates, one is, what is more humane? Is it more humane to send someone to languish in limbo and crush them in Nauru, or in PNG, or in Malaysia? It's a non-debate. It's not a true debate, because in all cases the proposal is brutal and beyond the pale, because in all cases what we're talking about is unnecessarily and quite potentially unlawfully harming innocent people. In fact, a lot of the debate in this country at the moment has descended to depths where really The political jousting is about how harshly we can treat vulnerable people, instead of a bigger question, and that is how do we properly and humanely and fairly manage a deeply complex situation in our region. And it's on that score that I think we need to move beyond a simplistic and distorted debate about whether it's onshore processing or offshore processing. I want to clarify that and say that I'm not for a second suggesting that we shouldn't process people who come to Australia in relation to their refugee status. But what we need to do is in fact seize an opportunity here, a different type of opportunity to the one that I just referred to before, and that is the opportunity that the High Court has thrown up, not deliberately but inadvertently in its decision. And that opportunity is to develop a policy in our region which is genuinely focused on providing stabilised and secure conditions throughout the region, or far better protection structures throughout the region for the so many people moving through our region in search of safety from danger. And it's in that way that the benchmarks, the legal benchmarks set out by the High Court about what it is that is required to ensure that anyone were to be expelled elsewhere to a situation of safety, what those benchmarks are, is part of, I think, the solution for the future. But really what we're talking about is creating in the future, working patiently and cooperatively in the region to develop better structures, regional structures for protection based on three key things. One is ensuring that wherever someone goes they receive fair processing. Secondly, that they are humanely treated. And thirdly, that if they're found to be in genuine need of refugee protection, that there is the availability of resettlement within a timely fashion. That is the type of situation, that is the type of structure which could move us beyond the debate that we have at the moment, which is not really focused on the protection of people, but rather the protection of borders. Thank you.
Well, thank you very much. I'm going to speak from the chair instead of the podium. Thank you very much for three really insightful and I think very timely reflections on where we're at. Before we open this up for questions, though, I'd like to take 5 to 8 minutes to take off from David Mann where you ended and ask the panel, where to now? We're in this gridlock. Where to now, politically, socially, humanely, and legally? And open this up to the panel for some discussion. And I'm not fussed who wants to start.
Where are we at now?
And where to now? How are we going to break this deadlock?
Yeah, well, it's very difficult to see at the moment how we break it, because I think one of the real difficulties at the moment, and I think this shows you how what a deep problem we're in, is that the response in relation to the High Court decision, which was a classic rule of law decision, was in fact to propose amendments to the law which oust the law, which literally strip bare, or seek to strip bare, basic protections for people that come here, and instead give almost unfettered power to the Minister of the day to send an asylum seeker anywhere without even needing to consider what would happen to them. So I think we're in a very dangerous situation at the moment, where there are even proposals, as I say, to depart or deviate radically from ordinary standards that we have about ensuring that the law governs these matters to somewhere else. And I think that we're in a very dangerous territory.
But that's not new, though, is it? The response of the executive, consistently to court rulings on these matters has been to rewrite the law.
Not always.
For the last, the last 20 years or so.
Not always. I mean, I think that sometimes, but I think that the way in which it's been done this time is it shows you the depths to which we've got to. I think that, for example, last year, the decision of the High Court to ensure that people that come by boat have the law applied to their cases rather than not, has not been, not been an attempt there to change the law. There are circumstances where there hasn't been, but I think that It's really the nature of the attempt too, the radical nature of these laws, which I think is deeply troubling and shows that really what we need is a different form of political leadership.
Well, I mean, the first proposal of the government after the High Court's decision came down to fix up its little problem was to strip entirely all protections from the law. Entirely. Everything. Gone. And the opposition had to point out to them that at least they might like to keep protection of non-refoulement, which is an ancient, fundamental rule of civilised nations, that you don't send people away to countries where they might face death and persecution. I mean, a fundamental notion of civilised behaviour had to be pointed out by the Liberal Party. I mean, that was a moment for me to understand the brutality of the politics of the boats. And I don't know the way forward from here, but I think it's going to have to come from within the political parties themselves. It's clear, the last decade has shown that it is clear that on this subject, if the coalition parties are going to be aggressively pursuing what are racial politics, and are indisputably, to my mind, racial politics in the domestic framework of this country, Labor will follow. And the decency of the conduct of politics in this area, in this country, seems to me, alas, to depend, I withdraw alas, it depends on the health of the Liberal Party. And all of those decent people inside the Liberal Party, those decent people who vote for the Liberal Party, the decent people who are clearly shown up in polling, who have profound worries about what's going on in this area, need to assert themselves inside their own party. Ditto people inside the Labor Party. Those party structures are going to have to work to begin to make profound policy changes, because without them, I can't see how we break a cycle of these kind of cage fights in Canberra over this small, manageable issue of refugees.
Can I just ask, Dave Collette, just following on, does it really matter what the public thinks?
Do you know, it's one of the things that struck me about the Go Back experience was that the political system just didn't engage with it. So there was a real sense in the, from the participants and also from viewers. And, viewers, we had, at the peak, we had 600,000 viewers and MasterChef had 1.5 million. So, we're talking about a small segment of the community. But actually, I think the rating numbers don't reflect the extent to which the show impacted on debate, I think, within the community. I think, lots of students have watched the show as part of their school, and so the impact continues. But I was struck by the sense that the political class simply, or the politicians at least, didn't engage with it. And so there was a sense, I think, on the part of the participants, or some of the participants at least, that change was possible. And also I think from, if you look at the website, the SBS website, and people who have seen the show and responded to the website, the way they talk about it changing their attitudes, there is a sense that it's possible for people to get an insight into the realities of what it's like for refugees and asylum seekers, and to also think about what that might mean for Australia's response to refugees and asylum seekers. But I think, as far as I know, Joe Hockey just called it a stunt, and that was the extent to which he would engage in it.
I think it's a very complex dynamic, the one between the public and political leaders and this issue. But I think that one of the tragedies in recent times is that around 3 years ago, with a new government, regime change, if you like, there was something very unusual in history actually that happened, and that was that the government embarked upon a systematic program of restoration of rights, and it was restoration of rights to refugees. in this country, and it's been easily forgotten, but it was actually very important, and potentially was a real circuit breaker and a different way forward, if I can say that, way ahead. It abolished the Pacific Solution, and with it the notion of offshore processing. It abolished temporary protection visas. It at least promised the end to mandatory indefinite detention. It hasn't been delivered, but it promised that on paper. And it did other things too. It restored work rights to as many asylum seekers in the community. There are a whole range of things. It's very unusual for that to happen. But one thing that didn't happen with it was really any serious attempt by the government of the day to bring people with it on this. There was no narrative with it. There was no story. And I think that is a very unfortunate thing because it would have required political leadership. It would have required a change of story in this country. Why are we doing this? Why are we restoring rights to people and allowing them to stay and be processed here? And then all of a sudden, boats, more boats, without a narrative.
Which were blamed on the reforms by the opposition.
And there was no alternative narrative that was in place to fall back on. That's the point.
That's the point. And I think that's a tragic thing in this country.
And I think the government at the time had the political capital to be able to go and make that to make that narrative, and it was one of the few issues that it just had the opportunity and let it slip.
In the dying days of Rudd's rule, he began to make an attempt to persuade the public about some fundamental facts in this. And one of the extraordinary things about this issue is how impervious it is to fact. And I'm about to bring out a book on panic in Australia and the way in which panic governs so much of the politics of this country. But it does strike me that one of the things about panic is that when you're in a lather, when you're in a complete lather, you don't absorb facts. And the facts of this issue are so simple, really. And the other day, the Scanlon Foundation that I mentioned once again confirmed what many pollsters have shown, is that Australians have no idea how many boat people come to this country. None. Something like 10% of the survey the other day had a rough idea that boat people make up 1 or 2% of permanent arrivals in this country every year. 10% of the nation. But they've been told that for years.
Yes, but what do governments do when they want people to know the facts?
They could have an advertising campaign.
Have they?
No.
Have they bothered to actually even tell people? Which political leader in the last decade has stood up and said, this is why people come here, and this is why when they come by boat, almost all of those people are granted, under rigorous examination, granted refugee status in this country? How many have done that?
None. And indeed, no political leader since that first boatload of Vietnamese arrived in 1976, no political leader in this country of any of the big parties has ever done anything but demonise them. So it's no wonder we are in the situation we are in.
This is probably a really good time now to throw it open to the floor. We have 10 minutes left.
I'm a Masters of Global Communications student here. I'm just wondering, you say that politicians are not good at delivering the facts. What about the media? What's the role of the media in separating out the fear and the fact in this debate?
I can only admit to just about complete failure. I've been writing again and again and again for 10 years what David said. There's no such thing as a queue. A recent poll found that 62% of Australians are convinced that boat people are queue jumpers. I've been writing again and again and again, as have many of my colleagues, that it breaks no law to come to this country by boat to seek refugee protection. 61% of Australians believe that laws are broken, that they are illegal. Now, I know that there are sections of the press which are using this issue to undermine the Labor government. And there are sections of the press that are just trying to report what's going on. There's nothing unusual about that. That's the way it goes. But certainly, the press can't claim to have had any great success in illuminating the Australian people on the pros and cons of this issue.
They've had great success, I think, in some ways, though, in feeding, I think, fears, feeding misinformation, peddling or perpetuating the peddling of myths. It's on a fairly. I mean, one of them that I think is potentially one of the more insidious is the old stereotype which comes back in recast form often. Recently, it's been that if an asylum seeker in detention has an iPod or wears a T-shirt that doesn't have holes in it, or takes multivitamins, or even smokes, that somehow they can't be a genuine refugee. And I know it sounds ridiculous, but that's actually, those sorts of myths end up sometimes on the front page of papers, and they're deeply damaging because, as we know, what they do is distort a simple truth about refugee status, and that is that it's essentially egalitarian, that refugees come from all corners of the globe and from all walks of life, and are people like us. And those sorts of, I think it's those sorts of those facts and the distortion of them that sort of lays the foundation for, I think, a very deeply disturbing campaign often of misinformation.
Well, that great front page of the Herald Sun the day after the High Court decision, do you remember it? Picture of a boat and a huge headline, "Here they come." So feeding the very fundamental notion of invasion, the feeding the fundamental fear. Now, boats will come, that's true, that's absolutely true. But that was the first response, boom.
We could actually go for another couple of hours, and so I apologize to those who would like to have more of a debate and more questions. But can you please join me in thanking our panelists for very insightful presentations.